My lord, mentioning for a contempt application.
Contempt application.
Contempt application. Your Honor passed an order on 6/9/2024. It is the matter of illegal construction, and the order to consider the regarding matter to the Gram Panchayat, but they didn't have taken any steps and comply Your Honor's order.
2024 now 2026. 1 year already lapsed.
Yes, my lord.
1 year already lapsed.
The contempt has been filed in 2025.
25.
Yes, my lord.
Not listed.
Yes, my lord.
Okay.
So for early hearing of the matter. Must be blessed.
One top আছে টপটা হবে today read matter, so it will not taken up. Tomorrow one. Today is the read matter, so only read matter will be taken up as well as assigned matter. Okay. Judgment copy তুমি রেখে দাও। এটার কথা বলছি। 3. কি করবো? ডিসমিস করে দেবো? ডিসমিস করে দেবো? আসছে না তো। সবই তো একই মেটার। ডিসমিস করে দিই 2009 মেটার। Same order. Dismiss for default. Same. Dismiss for default. Same. Dismiss for default. Same. It is also same.
Lord, I beg to approve there the petition and lordship. On the last occasion, lordship is directed to serve notice upon the state council, my lord, that has already been complied with. But on the two consecutive date, my lord, state is not coming. Lord, it's a serious matter regarding unauthorized construction over the school property, my lord. I am representing the school, lordship.
So go before the civil court. What writ court will do?
My lord, fact
With
is
regard
that
to the application.
it is the district magistrate and the SP should act because it is a school property, my lord. And the school have no authority to remove the illegal construction by itself.
The property, the playground of the school has been encroached by illegal shop owners since long
Lordship,
time.
and several
So what writ court will do?
my lord, direction
Action against them
direction
in
upon
accordance with law.
direction upon the authority concerned to remove the
How they will remove
lord,
without due process of law.
my lord,
Your contention is that they were encroached the illegal school playground by constructing shops. What state will do? Take its appropriate steps in accordance with law.
lord, fact is that school comes under state, my lord. School is it's a government school, my lord.
The state will remove the illegal encroacher without due process of
No, my lord,
law.
according to with due process of law, lordship, they should serve notice upon them. They have no right to encroach the property, to run the business on the property of the school. That has already been duly acquisition has been done
By whom?
by the DM in the year 1958-59.
And now you are coming
No,
for
my lord, at that point of time, there was nothing. My lord, kindly see my representation.
where is your representation?
My lord, page 2730. Lord, kindly come. It is a Bengali language, my lord. Page 27, my lord. This is one of them. There are other several representation given to the Egra municipality, Purbo Medinipur.
(1958).
Lord, kindly see page 30. That was the LA department notice, my lord. That has been settled already. Property has been acquired in accordance with law.
Whom you have served the copy? Whom you have served the copy?
My lord, copy has been served upon the all concerned, my lord. All the respondents.
Please file the affidavit of service.
My lord, on last occasion I have served, my lord. I have already.
No, thereafter I have directed some.
Yes, my lord, that some Sahima Sumi appeared on second. No, not on second, my lord, earlier date. And lordship directed to issue notice, my lord, I have already served.
No, thereafter I passed the order to file a report in the form of affidavit by the state.
That has not been done, my lord.
So, to inform this order to the state, I am giving you liberty to communicate this order.
My lord, I got my lordship.
And none appears on.
Ten Lordship, I am for the petitioner led by Mr. Shumitabu Chakraborty, praying for not this week, Lordship.
No, last occasion nobody was there.
Lordship, I am only praying for not this week, Lordship.
What is the matter about? You know about the matter?
I am not.
You are not aware about the matter.
Yes, Lordship.
You are advocate on record.
No, Lordship.
Okay. No. You inform your senior. This is the last chance.
Yes, Lordship.
The next day I will dismiss the matter.
And I am for the petitioner.
This is assigned matter.
Yes.
Have you served the copy to the other side?
My lord, other side is appearing, my lord, on the last occasion. We were not present. Other side was present.
Not maintainable.
Yes. Why, my lord? Nothing. We do not know.
Appeal is
My lord,
lie with the order.
appeal lies not at all. Not at all. Not at all.
At all.
Not at all. Revisable order. My lord, this is, my lord, what happened. An application under Order 39 Rule 2A in connection with a title appeal has been, my lord, rejected.
2A.
Miss case under 2A contempt. Violation of order of injunction.
That was
Dismissed.
rejected.
Dismissed. That is, my lord,
There was a interim injunction.
not, yes, there was an interim injunction. My lord, now, my lord, that injunction, my lord, has been made absolute. The appeal itself has been allowed in our favor.
Okay.
But the contempt application was filed at a point of time when an interim order of injunction was there. Now, my lord, that was dismissed only on the sole ground that our case was that in violation of the order of injunction, you have destructed the suit property and had made construction thereon. That was our allegation in the contempt application in the Miss case. Now, court
By
has
the defendant.
by the defendant. Now, what happened? The learned first appellate court, granted ad interim order of injunction and ultimately had passed a decree for permanent injunction. Appeal is allowed. Now, court rejected my Miss case solely on the ground that we had filed an application. We did not file any application for local investigation to show what is the situation of the suit property. Here I have twofold grounds. Court had completely overlooked its own records. 26 application was filed. It was moved by way of put up. Other side appeared and said that they will file a written objection. Thereafter, the order 26 rule 9 application was kept pending. They were disposed of. One. Number two, in their written objection to the Miss case, they admitted that the suit property admitted the presence of the suit property and about the construction. They have even stated that construction is going on from 2014.
So that order is not appealable.
Kindly see order 43 rule 1R, then I will be relying upon, had it been the contempt application Miss case filed before the trial court, then appeal would have led before the the first appellate court. Here, the contempt application itself was filed before the appellate court. There is no provision of any second appeal. Now, Lordship would kind enough to see order 43 rule 1R.
(43)R(1).
Order 43 rule 1R.
Yes. An order under rule 1, rule 2, rule 2A. Yeah.
What will lie? Miscellaneous appeal. Very well. Kindly takes up section 104 of the Civil Procedure Code.
Yes.
Kindly see. An appeal shall lie from the following orders, save and except expressly provided in the body of the code by any law for the time being in force or for any other orders. A, an order under section 35A, an order under section 91 or 92 refusing to grant leave to institute a suit. Then the G, then an order under section 95, an order under any provisions of the code imposing penalty or fine, directing arrest, detention in civil imprisonment or any person except any person except where such arrest or detention is in execution of decree. I fall within H. If the contempt application was allowed and the defendants were punished, then under section 104 appeal lay. Here, order 39 rule 2A, which was contemplated under order 43 rule 1 or rule 1R, has to mean, when punishment is given. Here my contempt application was dismissed.
Okay, let other side comes.
They were so vocal on the other side, not maintainability tomorrow.
I am fixing another date. Let them come. Otherwise, I will dispose of. None appears on behalf.
I will.
Formally admit করে
Judicial is directed to learned counsel appearing on behalf of the opposite party in the meantime.
I will intimate that date. Milord 12, Milord, kindly fix it, Milord, on 7th, Milord.
7th.
Yes, Milord.
Okay.
Amar. Milord 13, I appear for the petitioner. Milord, today morning the learned advocate in the trial court intimated me with the sole petitioner had expired. I have to take steps, Milord. There's only one.
Fifteen, Lordship, I'm for the petitioner, Lordship. It's a
Responded.
yes, Lordship. It is a change brief, Lordship. Have received the instruction in terms of their opposition, Lordship, from by last Monday, Lordship. I kindly keep this matter on next week, Lordship. I will file my affidavit in opposition reply, Lordship. It's a kindly give me a last chance, Lordship.
The last chance.
Uh,
This matter was fixed today as a last chance.
My lord. In fact, on last occasion it was dismissed for default. Later on, they came, my lord. They mentioned the matter. It was restored, my lord. They have been given one last opportunity.
Lordship, I'm late by Mr. Kolal Basu, Lordship. I'm praying for a
Maybe.
maybe, Lordship. It's my. I'm praying only a bunch of Lordship. Kindly give me a bunch of last chance, a bunch of Lordship. I will file my reply.
5,000 cost paying, then I will allow. If you want to adjourn,
Lordship, it is a change brief. I'm not an advocate. At the first time, I am not filing file this writ petition.
tomorrow
It's a change brief, Lordship.
come and say.
No, Lordship. Tomorrow, sir.
1 month ago, my lord, he was briefed, my lord.
But I need a bunch of certain instruction in terms of their opposition, Lordship.
Sir,
Yes, Lordship.
your name.
Nilanjan Pal, Lordship.
The last occasion who appeared?
Uh,
Said.
Sijita Sen, he is a junior of Mr. Kolal Basu, but he is not an advocate on record. I am not a change brief advocate, Lordship.
In this way, I will not allow.
I'm praying, Lordship, only, Lordship, kindly.
Cost should be paid to the opposite party. Respondent.
Lordship, kindly pardon, Lordship. I'm praying, Lordship.
Cannot adjourn the matter. How many occasions I have adjourned? 1, 2, 3,
No, Lordship, not
the
three.
3 occasions.
No, Lordship. Yeah, this is the third occasion, Your Lordship.
On 14th January 2026, you were not there. On 11th February 2026, you made a prayer. On 2nd April 2026, you made a prayer. Matter was adjourned as a last chance.
Lordship, February, I am appearing in the month of
You are
February.
not aware about the record. How you are dealing with your client after getting the non objection from earlier advocates. Why you have
Kindly
not
give me a
gone
last
to the
chance, Lordship. On next week, on next week, I will heard the matter, Lordship.
payment of cost?
But Lordship, kindly pardon, Your Lordship.
How much cost you will pay?
I'm not nothing.
2,000 cost you have to pay.
My lord, I beg to appear for the petitioners, my lord.
What is the matter about?
My lord, the matter, my lord, the petitioners, the junior counterparts were switched over to the petitioners, my lord. This is the matter where, my lord, the petitioner was recruited in the year 2013, and my lord, they were time to time they were promoted, my lord. But in the year 2020, my lord, when the Kolkata Municipal Corporation, my lord, issued the, my lord, the promotion list, my lord, they have switched over the junior counterparts, my lord. To that, the petitioners, my lord, submitted representation, objection, my lord, but without entertaining, my lord, the authorities, my lord, they published the final gradation list, my lord, wherein the petitioners were, my lord, given the, my lord, lower uh, place, my lord, and the juniors were, my lord, switch over, my lord. So, my lord, agree by that action, my lord, the petitioner preferred the writ petition, my lord.
Before final gradation list, you have made an objections. before the
Lordship,
authority?
lordship, I have made your lordship. Objections filed before the authority, my lord, that was not considered, my lord. And after publication of the final gradation list, my lord, this writ petition was, my lord, preferred, my lord.
When you have appointed,
2000, my lord, 13, my lord.
where is the gradation list? Please show
My
me.
lord, the
You prepared the list of dates.
lordship,
It will be helpful for the.
lordship, I will come with list of dates and one, my lord, the brief notes of argument I have prepared, my lord, and kindly fix a date, your lordship. I will come.
Date, both
Lordship,
will be-
kindly, my lord.
Corporation is the contesting party.
Answering respondent, my lord.
They are not, you are representing whom?
Mr. Ghosh, Alok Ghosh.
No, you are for
representing
state.
State.
State. Answering
State has
respondent
nothing to
is
do.
not there.
Here, my lord, in this matter, my lord, affidavits were exchanged, my lord. They have filed their opposition. We have, my lord, filed the exception to the opposition, your lordship.
I am fixing another date. You inform the corporation,
Lordship,
municipal.
my lord, I will.
Fourteenth May.
14th May, lordship.
After
Mirror.
May.
দিয়ে দিল। Great.
17, my lord, I am appealing for the petition. But I am filing my reply.
And for the respondent number 224.
Opposition has been filed.
Opposition has been filed, reply. In Act 25.
Opposition has been filed by the respondent number 2, 3, and 4.
Yes,
2 to 4.
2 to 4.
2 to 4.
2, 3 and 4.
2 to 4.
And now, my lord, I am filing my reply. But here the case of the petitioner, my lord, is that the advertisement has been published for the post of peon, my lord, being under the Punjab National Bank. My lord, that is 17 post of peon has been published in the year 2021. And the advertisement annexed, my lord, page 21 of my writ application.
For the post of peon,
Peon,
general category.
yes.
All are general category.
Petitioner is the general category.
General.
My lord, there are general category,
Other,
reserved category, OBC. Page 21 is the advertisement.
yes.
But there was the, my lord, 17 total post that your lordship got, my lord, শূন্য পদের বিভাজন. That is next Purulia Jela 8 and Bakura Jela 9. My lord, I am in the district of Bankura. Bakura.
District of Bankura.
Bakura. And then, my lord, অসংরক্ষিত 6, EVBUS 1, SC1, ST1, OBC 6. And for the post of for the district of Bankura, that is total 9. অসংরক্ষিত 6, that is for Purulia 3 and for Bankura 3. Total 6 অসংরক্ষিত, that is total 6. Total 17, 2 district, Purulia and Bankura, total 17 post. And for 17 post, Purulia 8 and Bankura 9. অসংরক্ষিত 6, that is for Purulia 6 and Bankura 6. That is unreserved. And my lord, your lordship, kindly see the bottom. That is প্রার্থী বাছাই পদ্ধতি.
How you can divide 6, 6?
মানে that is total অসংরক্ষিত 6 total, then Purulia 3 অসংরক্ষিত and Bankura 3. That, my lord, I relied their opposition.
6,
6
1.
E1 SC3 ST1 OBC 6.
The
Total 17.
17.
7.
How you can divide Bankura and Purulia?
Purulia, my lord, that is শূন্য পদের বিভাজন. Purulia for 8, Bankura for 9.
Where is that?
মানে that is top অসংরক্ষিত, then top শূন্য পদের বিভাজন. Total 8, total 9.
Okay.
Then, my lord, bottom প্রার্থী বাছাই পদ্ধতি. কোনো ইন্টারভিউ করানো হবে না এবং কেবলমাত্র বয়স ও প্রাপ্ত নম্বরের নিরিখে প্রার্থী বাছাই করা হবে। প্রাথমিকভাবে বাছাই করা প্রার্থীদের নথি যাচাইয়ের জন্য ডেকে পাঠানো হবে। পুরো প্রক্রিয়ার যে কোনো পর্যায়ে যে কোনো দরখাস্ত বাতিলের অধিকার ব্যাংকের থাকবে এবং কোনো পর্যায়ে যদি এমনটা পাওয়া যায় কোনো প্রার্থী নির্ধারিত যোগ্যতামান পূরণ করছেন না এবং বা তিনি পুরুষ মহিলা ত্রুটিপূর্ণ মিথ্যা তথ্য শংসাপত্র নথি পেশ করেছেন অথবা বস্তুগত সত্যের অবলাপ করেছেন, সেক্ষেত্রে সংশ্লিষ্ট প্রার্থীর প্রার্থীপদ বাতিল হইবে। That is the page 621.
অধিকার এবং ব্যাংকে থাকবে।
Yes. Then page 22, my application form.
Yes.
And my lord, educational qualification, that is
from top 1, 2, 3, 4, 5, 6 educational qualification.
Yes.
That is, I got SSLC marks 93.12. Date of passing, that is Madhyamik examination, my lord, the petitioner got. And then 12, the petitioner got 90.8. This is the marks. And my lord, page 23 is the all the document which was annexed in the application form. And the mark sheet, then I annexed the mark sheet. And then if your lordship come straight away, the page 34.
34, yes.
Page 34 is the shortlisted candidate for recruitment as peon in subordinate cadre. In the shortlisted candidate for recruitment as peon in subordinate cadre, the name of the petitioner was not appeared. And if your lordship kindly see from bottom, third candidate,
Akash Dutt.
Akash Datto, got 82.2, who is general category. And my total marks is 91.7%. And Akash Datto got 82.2 shortlisted candidates. Other candidate is there. My name was not appeared. Then I made representation before the authority concerned.
Now merit percentage, you come to the merit percentage.
Yes, merit percentage, if your lordship
That is
kindly
based
come.
on the marks obtained in the.
Yes, only marks, that is percentage total. Akash Datto got 82.2. I got 91.7%. That is only the marks obtained in the Madhyamik and HS.
That is only criteria for selection.
Yes,
Not
only
shortlisted.
criteria shortlisted. No interview has been
No
taken
interview,
place.
but marks.
Marks, my lord, my marks in total 91.7%. Aggregating Madhyamik and HS, high secondary. And Akash Datto gave shortlisted candidates who got in percent, that is 82.2. That is lower from me.
That is only the criteria for selection or shortlisted.
Shortlisted. Then your lordship kindly come page 36, my representation.
Yes, 36.
Page 36. Elaborate representation, my lord, disclosing everything.
Yes.
That is the criteria as well as my percentage marks. That is Kuntal Mondal, serial number 4, 91.7. That will be the result, but they did not follow the same. That will be the result in general candidate by percentage, marks of percentage. And they did not reply anything. Then writ application has been filed. And after filing of this,
Get the party Akash Datta.
no, my lord, that
Why you have not met the parties? He is the person who will deprive if order passed against him.
my lord, they gave him shortlisted candidates. They choose shortlisted candidates.
Your grievances against the Akash Datta.
My lord, entire, that is the recruitment policy. Yes.
You are unsatisfied with his marks, that his marks is lower than your candidate. So you are
And-
asking to remove him.
Yes,
from
my
the
lord, that I will.
candidate. Why you have not made
That
party?
if your lordship directs me, then I made him party and sub.
He will
copy.
be the.
And if your
person
lordship
who
kindly
will
say
deprive-
their opposition, they file opposition. Already they file.
Who?
Respondent number 2 to 4.
What are their contention?
My lord, their contention nothing. They citing some judgment and they disclose that same thing, that Purulia district for the total post, Purulia district 8 and Bankura district 9, general 6, and they did not even follow that general candidate number is 6. They did not follow. They did not appoint any general candidate. Only one candidate has been appointed and remain vacant 5 candidates. And they did not disclose anything about the of my poet, why Akash Datta has been lower marks given shortlisted candidate, they disclose nothing. Only citation has been made, and that is elaborate. Page, no annexure, no disclosure. Why the petitioner did not give a shortlisted candidate in spite of having higher marks? This did not disclose anything. And then
only 3 general candidates were selected or
only
shortlisted. Only 3.
There are 6 candidates. And if your lordship, my reply, I disclose one document that was delivered from the office of the respondent authority. If your lordship kindly see for a moment, page 9 of my reply. My name is in the shortlisted candidate, but that was deleted subsequently. Page 9.
Yes, page 9.
Page 9, my lord,
Which
from
serial number?
my lord, from bottom third.
Kuntal.
Yes, my name is there as a shortlisted candidate, and they deleted subsequently. They deleted me. This was their document, and I got from the office of the respondent.
How you have obtained this document?
My lord, that is I obtained from the by way of application, and they delivered me previous shortlisted candidate. And then, my lord, if your lordship kindly see for a moment, page 15, the disclosure. Page 15, they deleting my name, another candidate given shortlisted candidate, page 15, and page 16 is the Malat elaborate discussion about the vacancy. If your lordship see that 6 general candidate, Malat Purulia 3, Bankura 3. And for Bankura 3, they did not.
Akash Datta was selected.
Yes.
He was
Yes.
selected. So he has to make party.
Yes.
You have to make party.
Then, my lord, the address of the Akash Datta, my lord, is not available to the petitioner. If the respondent authority provide me the address, then I.
Yes, what is your
avail-
contention?
Lordship, the learned counsel Mohit Gupta appearing in this matter on behalf of the respondent, Lordship. Lordship, kindly fix another date for hearing. He is not
You have
available
to submit this at the
I
initial stage.
note his point, Lordship. Kindly give. I have already filed my opposition, but hearing, Lordship, kindly give another chance for our reply on behalf of the bank, Lordship. I have filed my
Yes,
opposition in
You want
respect
to
of
add that
My
person?
lord, if my learned friend able to provide the address of Akash Datta, then, my lord, I am able to serve him, because
he
there
has
was.
appointed. He
Yes,
will be
yes.
the person who will be
Then,
deprived.
my lord, the address of the
result
Akash
of the
Datta is,
petition will
my
change.
lord, my learned friend have the address of the Akash Datta, because I have not able to add.
Lordship. I will try, Lordship.
You supply the address.
Give me.
18, my lord, I am appearing for the petitioner. My lord, I am paying only 1 day's accommodation. Only days. Reply, opposition reply already completed. I already filed my reply. And Union of India also filed, my lord, opposition.
Supplementary affidavit filed by
Yes,
you?
supplementary affidavit.
Against that, no opposition has been filed.
My lord, supplementary affidavit already I filed.
You have filed, but they have not filed
File any opposition. till.
opposition. Okay, none appears on behalf of the
Come for the petitioner, my lord. My lord, first and foremost, my lord, the two cans appearing in this matter, my lord, I desire to withdraw both the cans, my lord. They are now infructuous.
they became infructuous.
Yes, my lord. One is for early hearing and another is for interim order, my lord. I'm not pressing on the interim order, my lord.
So what
Let
is
the,
the
both the
case?
cans be, my lord,
What is
withdrawn.
the main case?
But the main case is in regard to I am challenging the orders passed by the disciplinary authority and subsequently by the revisional and appellate authority, my lord. My lord, before plunging into the case, my lord, one thing I desire to bring before your lordship is that in the opposition, my lord, the proceedings of this this disciplinary proceeding, my lord, those were not produced in any of the reply or their rejoinders, my lord. So, my lord, if my learned friend be directed, my lord, to produce the proceedings, my lord, the witnesses for whosoever if have been examined, that can be made clear, my lord. That would be, I suppose, necessary for going into the
First
depth of
place
the
your
case.
case. If
My lord.
necessary, I will ask them
Yes,
to
yes.
produce. What is your case?
My lord, my case is that it has been alleged that I was sleeping on duty. My lord, on page 3, my lord, I'm reading from page 3, paragraph 2, my lord. On 26th of October 2020, 21 hours till 5 hours of 27th of October 2020, my duty was at ISP Barnpur compound, where, my lord, while checking the AC plant at around 0055 hours, the allegation was made that I was found to be sleeping while being seated in my chair. Subsequently, my lord, no activity was there in regard to the set checking this observation for 2 months. After about 2 months, my lord, on 5th of December 2020, I was handed over an explanation letter, a letter seeking explanation for that allegation of why I was sleeping in duty. I had given an explanation. Well, the reply had specifically stated that I have been suffering from fever and body pain on that said day, and in spite of having advice to take rest by doctor, I was not allowed that rest, and due to shortage of staff, I was given duty, and there was consecutive duty, my lord. Due to which, my lord, I may have been exaggerated, I may have been felt tired, and for which
So
I had been found.
prior to so cause notice or when the duty was assigned to you, you have made a prayer before the authority for any leave.
My lord, there is no provision, my lord. This is a disciplined force. This is not a civilian force. This is not a civilian. I am having no opportunity for seeking any leave.
Civilian
Or-
post, if someone became ill,
Yes, my lord,
or
my
someone
job will
became-
go, my lord. My job will go, my lord.
you will not.
That is the fact, my lord. This is a discipline force that cannot be compared with any other civilian employment. I have been given arms.
You never get any leave.
We get a
That
leave.
job.
My lord, we get a leave.
So-
We get a leave, my lord. But my lord may kindly consider we are not officers acting in the CISF, my lord. We are very
Did
small.
you file any medical document or any?
Yes, but those medical documents have been brought in the record at the time of the pleadings that were not considered, my lord. That is the reason I am seeking a direction from your lordship upon the respondents to bring on record what are the documents on the basis of which this order have been passed, my lord. The impugned order have been passed. That is necessary, my lord. I have submitted the documents. Even, my lord, I have
What is the
submitted.
provision of leave in that service? Is there any leave provision or not?
My lord, there are provisions for leave. There
How
are
many
provisions.
leave you will get in a yearly basis.
My lord, that I have to take instruction, my lord. That I have to take instructions.
And what are the leaves available in that service?
My lord, that my learned friend appearing, my lord, she will be better competent, more competent to advise, my lord, on that respect.
You place your case first. Thereafter, I will ask them.
My lord, may kindly see my grounds. My lord, may
Suppose
straight away
you
come to my
show,
grounds.
is there any provision of leave or not? If there is a provision of leave, you must have to inform prior.
My lord,
Nothing was done, Lordship,
No,
and
no.
Lordship will see if your Lordship comes to the final order.
No, his case may be that he was suffering from fever.
That is
That
his
that
case. He's
that
made out
must
the
be
case,
brought to the knowledge
and
of
that
the
was also
authority.
considered. Lordship, the authority has also considered his explanation. So, but the punishment imposed, Lordship, is also commensurate with the offence. 2 days pay. It's a pay fine equivalent to 2 days. That was the punishment.
No,
He was-
punishment is punishment.
Punishment is punishment.
Whether that
Yes,
is
Lordship,
legal or
that was-
illegal, that
It
should
was
be
not
the
that he is. It's not
consideration
his
of
case
this
that
court.
I had applied.
That's why he came.
But
Yes,
Lordship, he had sought, he had given an explanation.
You have accepted, but you have punished.
That explanation was taken into account. He was found sleeping.
No,
Because
he admitted that yes, he was
it is an
sleeping,
admission.
but
And therefore,
his
when we find
condition,
a member of the force sleeping on duty, Lordship, we cannot just bypass that. Lordship will kindly understand our predicament. So we've really imposed a very,
minor
small,
punishment.
very minor, 2 days pay fine. Therefore, Lordship, in this matter, what I find is, Lordship, he is more concerned because the promotional avenues are stopped.
my lord, I'm not giving any word, my lord. I'm not speaking out a single word in regard to my promotion. I know very well, my lord, that only those 2-day pay fine will make a huge difference. But I will not make a single word, my lord, in regard to that, my lord.
Lordship will kindly see. It's not, he hasn't challenged the legality, propriety.
And yes, my lord, I have challenged.
Where-
My lord, kindly come to the prayer, my lord.
Yes, yes, please.
Infraction of any
Let
rules.
him
Let him
complete.
My lord.
Let him finish.
So, my lord, what happened, my lord? I have given each and every document stating that
Where
I
is
was
your
not.
reply? First, come to the reply.
Well-
What reply you have given? You have admitted that you were sleeping.
No, my lord,
at
there
that
is
point.
no dispute that I was not found asleep, my lord. It is admitted, my lord.
Admitted.
Yes,
facts.
my lord. I'm not challenging that.
Where is
But
your
why I
reply?
was found
Where
asleep,
is
my
your
lord?
reply?
If it is page 15,
No, 15 না, 15
And against that order, you have challenged the order.
But all departmental procedures avenues have been
That
happened.
was a form.
Yes, my lord. Appeal, revision, both have been done, my
What
lord.
remains? Now they have considered your prayer, reply.
My lord,
and
what has
thereafter
not been
they impose.
my lord,
How
what
court
has not been
How
considered?
court can reduce?
Yes, my lord. What has not been considered, I have stated in my ground, my lord. Kindly come
You
to the
have
ground,
given
my
you opportunity. You have given reply.
that is when
There is no any allegation against the principle of
Possible
natural
country,
justice or
page 11
arbitrariness.
of-
My lord, kindly come to the grounds, my lord. 4 grounds, my lord, that I have stated.
Yes.
The replies are
Which
page
page?
11 and 15.
Which
My lord,
page?
page 6, my lord, ground.
Yes.
My lord, I'm reading out the grounds, my lord. For that, no independent witnesses were produced by the prosecution and are examined by the inquiry officer disciplinary authority for establishing the charges against the petitioner.
This is
All
not
witnesses
required. This is not required because you have admitted that
My lord,
This is not required. Any
But
witness is
even-
not required once you
leaving it
have
by-
admitted.
Independent witness cannot be available in a.
Once you have admitted fact not required to be proved.
my lord, documentary
No
documents
witness-
have to be admitted, my lord.
No witness
Documents
is
have to be admitted, my lord.
required in
My
this
lord,
ground.
due to a shortage of staff in an unit, my lord, if one person whose duty is there for 8 hours, if he has been made continuously given for duties for 16 hours, then, my lord, is it not very much natural for that person
And
to
that
feel
was the
sleep?
ground of your reply.
That was taken as a ground, my lord.
In reply.
Yes, my lord, reply.
Next ground.
Shortage of staff, my lord, that has
on
not
to
been
the next-
considered.
Next ground.
No documents produced by the petitioners were examined and discussed by the disciplinary authorities while arriving at the conclusion of guilt, my lord.
Next.
Neither the disciplinary authority nor the appellate authority or the revisional authority have considered the duty roster of the petitioner and the duties that he was ordered and its resultant reaction or effect on the delinquent in discharge of his duties. The fact that the petitioner was granted 12 hours duties on 15th of October 2020 from 17 hours to 5 hours and on 16th of October 2020 and again 8 hours duty from 21 hours to 5 hours on 27th of 10 2020 was never considered in any of the findings or the orders, my lord.
Okay.
Lastly, my lord, it was never considered by any of the respondent authorities that the petitioner are made to perform and or over their reasonable capacity due to shortage of manpower and CISF, as a result of which the petitioner and other persons like him are constantly under the service-related stress and strain, which directly affects the health condition and the resultantly adversely interferes with the performance of duties. My lord, these are two vital points, my lord. My lord, a duty cannot be given beyond the stipulated time frame, my lord. These are not robotic persons, my lord. These are human beings who are performing duties. And even if there be shortage of staff, the natural justice has to prevail, my lord. These persons have to be given some rest. Without giving a person adequate rest, if a person is given duties after duties, taking the ground the shortage of duty staff, you have to perform your duty, whatsoever happens, my lord may consider one thing. These persons are not performing duties bare and or with lathis, my lord. They are performing with arms. So there has to be reasonable opportunity, reasonable care has to be taken of their health by the appropriate higher authorities, my lord. It is very natural that a person who is performing his duty consistently without any may fall asleep. So, my lord, if something happens, my lord, due to that, my lord, not only that person, the officer concerned is also responsible for that, my lord. I'm not going on those high up events, my lord, to the officers, but my lord, these things ought to have been considered prior to giving a punishment and prior to considering that what effect that even minor, very small punishment of 2 days pay fine has on the career of that person, my lord. Those are the things which were not taken into consideration either by the.
Where is your reply?
আছে
There is an annexed.
দেখো তোমার রিপ্লাইতে আছে বলে আমার কাছে মনে হচ্ছে
Lordship will kindly come to page 11 of the affidavit in opposition and 15. These are the two replies. Page 11. Lordship, I stand corrected. Read petition. Read petition, page 11. Read petition, na? Opposition. Oh.
Yes, which page you are referring?
11 of the,
page 11 of the opposition, yes.
it's not in the petition.
Yes.
Lordship, this is his explanation.
And I have stated in details, my lord, the tips in which I was given my duties, my lord, that I have
You
already
have
stated.
extra duty or not, have you mentioned in your reply?
That I cannot establish because I am,
How you can establish now?
well, I am very well acquainted
You have
as to.
give a concise and whatever your grounds for your reply.
I have stated my grounds, my lord. Now let the respondent deny that they have not given extra duties. Let them prove, my lord.
No,
I cannot. My lord, I am not having the official documents. I am a mere soldier.
Read your reply.
Reference to your office explanation, letter number such and such, dated 5th of December 2020, which desired that I was detailed for C-shift duty from 21 hours to 5 hours on 26th of October 2020 at WT WT stands for Watchtower, my lord. 237 Nala at Sea Company. At about 0055 hours on 27th of October 2020, surprise checking on respect of Assistant Commander of his unit was found sleeping on the chair according to GD number such and such on that day, that is 27th of October 2020. In this regard, I would like to submit few lines for your kind consideration, please. That on 26th of October 2020, I was suffering from fever and whole day body pain, and I was slackness, which not feeling good. Due to this, I was consulted to Dr. Sakila Khatun, Newtown, Banpur. She was advised to take rest, but due to shortage of manpower in this unit, I was not agreed with my lord, I cannot say that what is there. Duties, my lord. Admit and reported to duty officer. Duty take some medicine, copy enclosed. Beside, I need to appear for LDC during the year 2021 in CISF. This is for your kind explanation, please. Keeping in view the above and gracious be pleased, so cause and drop my charges for disciplinary action. Forward this explanation which will lead effect to my future career, as well as to appear for the said examination, and for this is possible only after great support from your side. My lord, these are the things, my lord. So, my lord, I have stated, maybe, my lord, some thing has been stated in regard to my future career, my lord, but I have stated in this explanation that I was suffering from fever, my lord. I have consulted doctor, I have given the copy of the documents, my lord, connected documents.
Lordship, then page 15.
Did you submit the certificate of the doctor that on that day you were treated by any doctor?
Not report sickness.
Report short for.
He did not report that he was ill. Then the question of giving him duty would come in.
Let him place his
Let him-
case whether he was suffering or not. First of all, he must have to support the document. Support his contention by a document. Only he has filed the prescription of Dr. Sakila Khatun dated 26/10/2020. Where is the receipt of medicine purchased by you? Where is that?
That is not there, my lord. That is not.
there.
But it is.
You did not also submit the certificate of the doctor.
Did not report that.
And even if you have shown to the doctor or consulted your doctor, this facts should have
But
been brought to the
these are
knowledge
the
of
documents.
the authority.
Well, these
Yes.
whatever your lordship is telling, we here in black robes, my lord, we are very well acquainted what ought to have been done, my lord. But can it be expected, my lord, that all these
What is the
documents can be?
result? Please come to the
My lord,
reason of their punishment.
The final order is there at page 16, my lord.
15
16, my lord.
of the writ petition.
No.
Of the writ petition or
No, my lord, the final order, my lord.
Lordship seeing the
there writ
affidavit in
petition,
opposition.
page number
No, no, my lord. The 16 is that of the reply, my lord.
Right.
Affidavit in opposition, my lord. Reply, my lord.
Lordship looking at the opposition.
16.
1/6, my lord. Annexure 6, my lord.
Lordship, the final order.
Yes.
This is 29th of January.
Where is the observation? Why they have not accepted your reply? Which paragraph?
Lordship,
Well-
kindly come to paragraph 2 and 3.
that point was raised by them. You should have informed them about the doctor advice to take rest.
He decided on his own.
They would not deny
Yeah, now it has been taken a point
the
that,
leave.
but not a single word has been uttered anywhere in regard to shortage of manpower.
Why they will? There
Maladji,
is no question
Maladji,
of
what
shortage
happens
or
on what happens on field, my lord?
duty assigned to you.
Yes, yes, my lord. I am
More
bringing to light.
important.
I
Duty
am
is more
bringing to light
important.
what happens on field, my lord. On field, a person reports sick, but it is being told to him that no, you have to perform your duties because, my lord, there is a shortage of manpower, and that person cannot deny, my lord. That is
Anything
what
else?
happens on field, my lord.
Anything else?
My lord, that is what is there on record.
Lordship will kindly see the final order. On the first instance, he has the
It
representation.
is admitted fact that he was
That
sleeping
is why we've taken
at that
fact
point of time.
he was found sleeping.
But
It is
no,
admitted.
whatever point he has
And-
raised,
and
it was
we
not
find that
mentioned.
he did not act as per the advice of the doctor. He should have submitted the medical certificate and asked for leave. That was not done. That he said.
Tell me there is a provision of leave. There was a provision of leave.
Lordship,
Can you tell me how many leave was available to the
Lordship,
person?
that I'll have to. That is not in my pleadings. How many? How 20 days medical leave is available.
20
20
days.
days. So when the doctor had advised him to rest, he did not pay.
No, there is no casual leave.
Casual leave, medical leave.
How many casual leaves were there?
15 casual, 20 medical,
Okay.
and 30 days earned leave, Lordship. So leave, it's not a case that there was no leave. But
Hearing concluded. You have filed the reply.
framed after this. Therefore, Lordship, I mean, after this document is dated 71.
71.
The rules have been framed in 2001.
Now we take into consider all these things. Grateful, my lord.
But in item 20, I appear for the respondent.
My lord, I am being led by Mr. Shantanu Maji, my lord. He is in court number 14. He's on his legs. I am praying for an accommodation, my lord.
No.
Then kindly short pass over of 15 minutes, sir. I am not being briefed properly.
Short pass over 15 minutes. The last chance has been given on the last occasion. Ask him to be present.
Same matter.
Same. Okay, pass over.
That father and son dispute, Lord. Lordship desire the matter should be settled out. I'm happy with the father, Lord. Very unfortunate father. I will respond.
What is the stage now?
But they did not do anything for settlement at all. Lordship desires.
May I start hearing?
Lordship only fixes a day, Lord certainly do it. So I was replying, in fact, At that point of
There
time,
is no any possibility of any settlement.
there is no approach by them at all.
Why they will approach? You should approach.
My juniors have regularly approached them, but nothing at all. The son has never approached the father at all.
What was the impugned order in this case?
But the order was in my favor. Partly in favor, partly means I tell you, Lordship, but my client is not challenging. My client started a business on the name of Vishwas Decorators in Srirampur. It was a very, very successful. And he purchased a property, a landed property, constructed a residential house there. Thereafter, he purchased another property which was let out to different tenants. Because there may be rainy days in everybody's life. We have also faced it and we really facing it now also. So naturally, we purchased the house so that this income may be augmented during the bad days. Now, when the scenario changed after the marriage of the daughter, there's one daughter who is 14 years younger to the son. The son was not employed. When
He has one daughter and one son.
One son. Son is elder, 14 years senior to the daughter. Daughter is much junior. Daughter was given in marriage later on. The son was given in marriage. Now, he was not employed at that point of time. He purchased a flat out of the money from the father. And subsequently, after marriage, there was a daughter born. My client paid him 15 lakhs of rupees so that this could be invested in the name of the granddaughter. Now he shifted his entire family, wife and daughter to the flat. I'm told that his
another flat,
which was
purchased by him,
by the fund of the father, because he has no income at that point of time. So my father has no grievances at all. My client has no grievances at all. Now he has purchased another, and he is an employee of this, very sorry to say, employee of this Honorable High Court. Now, my lord, what has happened? Suddenly, my lord, he forced my client and obtained 2 deed of gifts for both the properties. Both these 2 properties.
Both these
2 properties. One is a residential house where the father and the mother was residing.
Okay.
Daughter is already given in marriage, who is in in-laws house. Son has migrated to a different place.
And another premises is?
Another place is let out.
Business. Oh,
business
that
only
was let out.
Tenanted.
Whole property let out to
the tenants. First, second, third floor, both all let out. Now, both these properties have been gifted to the son. Now, what has happened?
Is there any condition was there in the gift deed?
But I'll tell you, Lordship, later on also. This is a gift, forcible gift. So forcible gift. So naturally, he has no properties. By then, the business also gone. He is now 86 years old. Now, COVID came in. So everything is now smashed to him, his life.
Any complaint lodged by the father against the...
Before the authority concerned on this senior
citizens.
Shortly, Sony Citizens Act.
Apart from that, another...
It was held in my favor.
Any other complaint lodged with regard to the forceful...
To the police also. There is a case with the police also, and there is a suit also. There are 2 suits also. 2 suits for 2 different properties.
For cancellation of the gift deed.
For cancellation gift deed. Now, before this...
What is the stage of that proceeding?
But I'm told that my client's evidence has been taken, but not concluded as yet. That was several months back. But recently I have no contact. I don't even know what's the sale.
So what offer has been passed by the authority?
Authority concerned that the residential house is given to me fully, cancel the deed of gift. And so far the
One cancelled. Though the
tenanted house
is pending.
Tenanted house, so far the tenanted house is concerned.
No, one suit is still pending.
Both the suits are pending. So far the authority concerned, that is under the Senior Citizens Act, that was directed that is so far residential house is concerned, the deed of gift has been cancelled. And has now been changed in my client's name also. The other one where the rent has been phased out, the half of the rent is
from the corporation.
Name
has been changed from
by cancelling the deed of gift from the registration office. Now municipality has cancelled it. This is my name. So far the other house is concerned where the tenants are paying the rent. Half of the rent was directed to be paid to my client. House was kept as it is in the son's name. Deed of gift was not cancelled. Now, I have not challenged. I could have preferred an appeal before the district magistrate, as per the act itself. My client said no. Afterwards, my son is getting. He's my son. Now, my son's conduct is very, very awful. He never visited the house thereafter. Mother fell ill because he's the only son. And mother has a cherish that his son will
visit him, visit her rather, and he will see the granddaughter also, but they never visited it. Ultimately fell ill, suffered 3 or 4 strokes. And at the last time, the nursing home said that there is no chance of a recovery, so better take her to the house. And for the 3-4 years, she remained, 4 years, she remained on the bed, having 2 nurses day and night. Now today, she has left it. Son did not perform the last rites also. Never came, never visited. This is the scenario of the son who is claiming the father's property. Very unfortunate.
What about the settlement?
But my client is ready to settle the matter.
Not sit.
They are not doing anything.
To sit or
Very adamant attitude. That's what my junior told me. Attempt we've made all out attempts to be done.
none appears on behalf. None appears on.
I am praying for accommodation. I am praying for extension of time for filing opposition.
I am dismissing this matter.
Item number 25. I am appearing on behalf of Eastern Coalfields Limited, led by Mr. Shivshankar Banerjee. My lord, there has been a direction to file a opposition. Opposition is ready. It's to be affirmed. Like your lordship, may let the matter be fixed any day after Tuesday, your lordship. 25 and 26.
My lord, I am for the petition. On the last occasion, your lordship will please to direct me to serve the notice upon the private respondents. My lord, I have served the notice.
You serve the government pleader?
Government pleader, my lord, state.
State
Chandicharan there is there.
Why you have not served the government pleader? Specific direction was there.
Well, in this matter, Mr. We went to the office of the government pleader. They say we has no record. You served them. So we checking that Mr. Chandicharan is appearing. So that's why we have served the notice upon the Chandicharan day.
So
Because
government pleader will direct you above the court.
no, government pleader say, well, you serve the notice. Well, that's why my clerk went there.
Here I have directed you to serve the learned counsel for the state as well as government pleader.
My lord, I have sent the notice also to the government pleader and Mr. Chandicharan.
Where is the service of government pleader? Why they will not accept?
Then, my lord, your lordship
Whether
can.
they have refused to accept your service?
No, those say because my clerk went there. They
They
say
will direct you be above the court.
then, my lord, your lordship, not this week. My lord, I will serve. I will again serve notice. My lord. I will serve notice. I will serve notice, my lord.
Lordship, may I have one indulgence, my lord? I am appearing in item number 24, my lord. I could not join due to internet connectivity, my lord.
So what court will do?
My lord, I am
Already your matter
I apologize, my lord. I was appearing, my
an
lord.
application for restoration.
My lord, kindly don't dismiss, my lord. Kindly keep it not.
Stating the all facts.
My lord, kindly don't dismiss, my lord. Kindly make it not today, my lord. I'll appear tomorrow, my lord.
No. Last chance was there. Last occasion also you were not there.
No, my lord. Last occasion I did appear, my lord. Respondent side did not appear. There were directions to file affidavit in opposition, my lord. My lord, kindly don't dismiss, my lord.
Wait, I'm passing order in another matter. Please support the learned counsel appearing. Sir, have you gone through the order of 11 February 2026?
Lordship, 11 February 2026.
You are not there. None appears on behalf of the petitioner. No accommodation is sought for. The case is adjourned for the day. And you are submitting last occasion. You are present. You make an application for restoration. I will consider at that point of time. Next.
Twenty-eight, I appear for the petitioner.
Lord, I appear for the KMDA in this matter.
In this matter, affidavits are complete. They have filed a deputy report.
Will be required because it's a challenge to the acquisition proceeding.
But that is on record. What they have documents, they have already filed their report in the form of an affidavit.
What is CRAN 3?
CRAN, my lord, it was an application for expeditious hearing. My lord, now your lordship will.
So I am hearing.
My lord, that is, my lord, not has become infructuous. Well, it is, my lord, the writ petition pertains to, my lord, the land acquisition under the Act 2, 1948 Act. One of the main contention of the petitioner is that the petitioner purchased the land, they are in possession, मतलब construction was there, मतलब they obtained, they mutated their name, मतलब corporation mutation done, BLO mutation done, मतलब plan has been sanctioned. Now, in accordance with plan, the petitioner started construction. All of a sudden, KMD has come up and demolished the structure containing
Without
the.
acquiring or requisition.
They are saying that it is a full acquisition. Kindly have a look, first, what is my case in the writ petition?
You have purchased the vested land.
If the acquisition is lawful, then the question of vesting or non-vesting will come. But if the acquisition is not at all valid, in that event, that question
Challenge the acquisition.
proceeding. Kindly have a look, the prior portion of my writ petition. A writ in the nature of page 34, my lord.
Yes.
A writ in the nature of mandamus to issue commanding the respondent authorities, particularly the respondent number 2 and them, not to give any effect of the outcome of purported acquisition proceeding being LA number such and such, the LA number 2 LA proceedings are there, or any other subsequent land acquisition proceedings so far the involvement of the subject plot of land is concerned, as the subject plot of land was never within the purview of the said LA case number such and such, or any other subsequent land acquisition proceedings, and the same was always outside the subject matter of the LA proceedings being number such and such, or any other subsequent land acquisition proceeding, and never been acquired by the concerned authorities in its true sense and meaning and purport in any manner whatsoever. Thereafter, my lord, a writ in the nature of mandamus do issue.
LA proceeding was initiated in the year 1977-78, and thereafter it was again LA proceeding was initiated after amendment of the Act in 1991 and 1992.
No, my lord, no.
Entire plot was acquired in two phases.
Two phases.
In the first phase, in the first, no,
Let him submit first.
in the first phase, a portion of particular tag number was acquired, where the structural portion was left outside the purview of the acquisition. And my
vacant land was acquired.
Only vacant land. From there, my lord, the gazette notification it is apparent. Now, my lord, my purchase portion was within that acquired structural portion. That will, my lord, in our deed also I will show you lordship.
Currently, structural portion was also acquired.
Yes.
Initiating another
Another LL proceeding. Yes, but for that
is in the year 1991 and
91, 92. But for that, my lord, no.
You have participated in that proceeding.
No notice, no compensation, no notice under section 3 of that act of 1948 was ever issued.
At that point of time, you were the owner.
I became the I purchased subsequently. Subsequently.
You can say that
no locus standi to
My lord,
that very
your
question
predecessor was there.
No, my lord, I will satisfy your lordship, my lord, saying that I have got full right, because if the vesting order is not, my lord, valid, my lord, that question whether pre-vesting or post-vesting.
Why vesting proceeding is not valid?
Well, that I will submit before lordship, my lord.
Even
My
law
lord,
is settled on that.
Please, let him complete first. He will give.
Now, my lord, kindly I will look, my lord. First, my lord, my annexure at page 50, my lord.
When you have purchased the
My
property?
lord, I purchased the property in the year 1994.
1994. So
now, my lord, kindly have a look, my lord, page 50 of my lord writ petition.
34 is the deed of conveyance by which you have purchased the land.
Yes, my lord.
Yes.
Now, my lord, kindly have a look, my lord, page 50 of my writ petition, my lord.
50. Yes. 50 is the plan.
No, my writ petition, my lord.
Yes, I am looking up.
Amended writ petition, because my lord, the writ petition was amended, my lord. Because my lord, one of the my lord, the writ petitioner was my lord expired. Thereafter, my lord, substitution was made, and thereafter, my lord, amended writ petition was filed.
Where is the amended writ petition?
No,
Yes, page number 50.
50, my lord.
Yes, 50. Yes.
My lord, 3, 4, 5, 6, 7, 8, 9, 10th line from the my lord, top. All that piece and parcel of Danga land measuring more or less 3 cutters, 14 cheetahs, together with structure standing thereon, along with opposite illegal occupants and all sorts of rights of ways. So my purchase, my lord, including the constructed area. But at that time, the construction was there when I purchased the property. Thereafter, my lord, kindly have a look, my lord. Page 60, my lord. Annexure P2.
60.
60. This is the, my lord, corporation mutation done in the year 2002. In the name of our predecessor, that is, my lord, corporation mutation certificate. Thereafter, my lord, kindly have a look, my lord, page 63. My lord, when my mutation was done, well, in the assessment record, it has been, my lord, categorically recorded that the property in question, my lord, comprising of 2-story dwelling house. Lordship, have you lordship? D, my lord, Roman 2 DH, dwelling house, 2-story. And my lord, my name is there, the predecessor or the petitioner's names are there. Ramavati Shah, Pradeep Kumar Shah, Nirmal Kumar Shah. They are the writ petitioners before lordship, my lord.
Yes.
Now, my lord, annexure P4, page 64, my lord, that is the, my lord, electric bill for the month of April 2022. My lord, it shows that in the name of Ramavati Shah, my lord, this is the, my lord, petitioner number 1 before lordship.
Admit that you have purchased the land, you muted.
No, my lord.
You obtain electricity, you are still residing there.
Still residing there. But that is the case because it is the case of the requiring body and the acquiring authority that possession was taken over. Physical possession was taken over from the, my lord, the recorded owners. In terms of Section 3 of the West Bengal Land Requisition and Acquisition Act 1948. But practically, my lord,
how the proceeding is illegal, why proceeding cannot be initiated against your
now, my lord, the vital document is, my lord, page 66, that is annexure P5. That is the Land Reforms Authority, my lord, mutated awareness, BLR. My lord, it is, my lord, BLRO, my lord, is the, my lord, Land Reforms Authority, my lord, if the property in question, my lord, was acquired, my lord, in that event, my lord, in terms of the provisions of law, my lord, our names ought not to be, my lord, recorded as the recorded owner. And when, my lord, it was recorded, my lord, it was recorded in the year 1999.
So your contention is that at the time of mutation, there was no any vesting or there was no any proceeding initiated against your land.
My lord.
That is your
My lord. My lord. That's why, my lord, in the, my lord, concern, my lord, record maintained by the, my lord, Land Reforms Authority, they have, my lord, mutated our name, considering all papers, documents, and, my lord, the relevancy of the any acquisition or requisition over the land. Well, my humble submission before lordship, my lord, it is the, my lord, BLRO in who should be, my lord, informed by the, my lord, acquiring authority or recording authority that if the property is, my lord, vested with the state. Now, my lord, page 71, annexure P7. My lord, thereafter the behavioral mutation in the name of other owners are, my lord, there. That is, my lord, page 66 to my lord 69. This is the name of other writ petitioners. Now, my lord, page 71.
Building plan.
This is the building plan.
When it was sanctioned.
My lord, it was sanctioned.
You have not annexed the back portion of the sanction plan.
My lord, 2022, because 73, your lordship will find, my lord, that is the, my lord, letter of the, my lord, Kolkata Municipal Corporation, my lord. That is with regard to sanction of the building plan, page 73. Your lordship kindly have a look, my lord.
73.
73. That is, my lord, the letter written by the executive engineer, building department, to Sri Rohan Adhikari, premises number 42A,
So you
Shantipur.
have been informed that the land was acquired by KMDA.
Oh, sorry, it was a subsequent letter, my lord.
They have
Subsequent,
informed-
after sanction of the building plan, my lord.
This is stop work notice.
This is stop work notice, my lord. My lord, plan was sanctioned in the year
8th October 2021.
8 October 2021.
Page 72 তে আছে নিচে।
Page 72 at the bottom, your lordship will find. Digitally signed by Devashish Som, dated.
Yes, thereafter they have issued a notice for stop work because the RS DAG number 3701P, which is belongs to you, was already acquired by KMD.
First of all, my lord, our names have been recorded, mutated. Building plan has been sanctioned, my lord, after proper.
In vested land, if someone name is recorded, he became a owner.
No, my lord, the vesting is, my lord, under challenge, my lord, because the vesting has been done, my lord.
What ground you have challenged? You have not stated as yet. What ground you have challenged the vesting or acquisition? You have not mentioned anything about the illegality of the proceeding.
Compensation দেয়নি কিছুই তো দেয়নি। এটাতেই তো acquisition challenge।
Well, the acquisition has been challenged on the ground of no compensation, declaration of any award, no notice under section 3 of the, my lord, Act 1948, Act 2. And
how notice can be served upon you when you
Well,
have purchased subsequently?
previous, there was no, my lord, service upon the previous owner also, because the previous owner sold out the property contending that till date no notice of acquisition or requisition received by him or her, and on the basis of that representation, my lord, we purchased the property.
So you are saying no notice was served upon you or your predecessor.
No compensation.
No award has been passed.
Passed.
Payment has been made.
Payment has been made.
Three grounds you have charged.
And, my lord, possession is still, my lord, with us. No physical possession was ever taken by the acquiring authority
Within 5 years. Okay.
within 5 years. And the land, my lord, has not been utilized. Now, my lord, in the 2013 Act, my lord, it is clearly stated if the same is not, my lord, utilized, in that event, the property has to be, my lord,
Return back
to the
person who.
My lord, my lord, my lord,
Even in the constitution.
my lord, and I will show your lordship some judgments on that point. Oh, my lord.
Do you have the judgment?
Actually, my lord,
you do not have that judgment.
I have, because I on several cases my learned friend contested the matter. I have got the judgment.
I don't think he will be able to cross the hurdle. The first hurdle he has to cross, that subsequent, as a subsequent transferee, he has the right to question that acquisition.
But I will satisfy your lordship.
Concluded.
Well, I will satisfy your lordship on that point, that I have got right to challenge, my lord. Lordship kindly please.
There are several decisions. I have brought all these.
I have also the documents, judgments.
State appear করেন
Let the state be notified. State
Well, we have served, my lord.
If the state will not attend the court, how many times court will
No,
allow
no, my lord, this is the affidavit of service, my lord.
affidavit of service?
We have served. If
And
they
by
don't
the
come,
petitioner is taken on. How long you will take?
Lordship, it will continue for some time.
In that event, my lord, other matters.
That
Passover matter, yes. The next date I will
Yes,
take
that
up.
would be better because after all.
Next
because
date. Please inform.
The only thing tomorrow, my lord, there is a matter fixed for me. Instead of
Tomorrow I will not take up
Then
because
they-
I will be not available.
আপনি বলুন না 65 may kind of be fixed also. বলুন না
Advertisement.
I will take up, you mention, okay?
Grateful, my lord.
Seventy-one, Your Lordship, appear for the petitioner. On the last date, Your Lordship, I had specifically stated that the prayers of the petitioner is restricted to regularization. Your Lordship, I have prepared a very short note. Lordship, may I hand over a copy? And upon night, একটু দেখিয়ে আমাকে একটু photo. So my prayer is only restricted to regularization. What am I aggrieved today? In 2012, I was engaged on ad hoc basis pursuant to an advertisement when your lordship had indicated that it was not a backdoor appointment, it was pursuant to an advertisement. Notification, lordship. Lordship, thereafter, with regard to, there are three petitioners. With regard to the petitioner number 1, he had participated in a written examination for 100 marks. With regard to the petitioner number 2 and 3, it was in the year 2014.
Written examination, only oral was there.
For the petitioner number 1, your lordship, there was a written examination.
For petitioner number 1.
For petitioner number, lordship, for the petitioner number 1, only interview.
Yes.
Apologize, your lordship. Only interview. Petitioner number 1.
And petitioner number 2.
2 is written 80 marks. 2 and 3, 80 marks, and 20 marks is for interview. So in both cases, it's 100 out of total 100. Now the first initial, your lordship, my note I've prepared, petition number 1, 2, and 3. The first initial appointment of the petitioner number 2 was on 23rd February 2012 for performing the job associated with the post of dock pilot on ad hoc basis. Page 56 of the writ petition. Lordship, may very kindly refers to the note.
Yes.
Page 56.
Yes.
Page 56, it states, only I'll read the first para. I'm directed to offer you a contract engagement for performing the job associated with the post of dock pilot on ad hoc basis under Marine Operation Division of Holdia Dock Complex, Kolkata Port Trust for a period of 3 years. Lordship, thereafter, sub-para 1, you will be engaged initially for a period of 3 years, and on expiry of the said period, the contractual engagement will be automatically terminated. However, on expiry of the contract, HDC, that is Holdia, and KOPT, that is Kolkata, reserves the right to enter into a fresh contract for such period and on such terms and condition as may be mutually agreed upon by the parties. So this arrangement, incidentally, in respect of the petitioner number 1, continued from 2012 till 25th March 2025 from my note, page 42 of the reply. I've annexed all the subsequent engagements.
Still working.
I'm still working and I will be able to work subject to a 3 months notice if tomorrow I'm given. That tomorrow we don't need you. Or tomorrow, suppose the advertisement is allowed to be continued and 3 regular dock pilots are appointed. Maybe on the 3rd day, I'll be again put on notice that you are no more required.
That is your apprehension.
That is my apprehension.
Anytime, any moment, they can remove from your service because
from the service,
according to them, this is not a permanent job, and you have been engaged contractual basis.
Grateful, my lord. But my lord, my case on the earlier date, what had fallen from your lordship, whether a vacancy existed at that relevant point of time. To that, my answer is the vacancy throughout existed from 2012 till 2026.
How many vacancies was there?
Lordship, the moment someone retired, the vacancies kept on arising since 2012.
Can you tell me how many vacancies are there?
As on date.
Vacancy was the vacancy, approved vacancy?
Lordship is asking as on date.
As on date or at that point of time when you have been engaged?
Lordship, at that point of time also there was 3 vacancies at that point of time. There existed. I remember having a certain from my clients at that point of time also there was 3 vacancies and subsequently it was the requirement is approximately 14. If I very correctly remember, approximately 14.
So now 14 vacancies.
Not now, your lordship. For the purpose of the job, 14 dock pilots are required at a time. I am giving us.
Requirement is different. I am asking about the how many posts are vacant and whether that post was sanctioned or not.
Lordship, if there is a vacancy, your lordship, once a vacancy arises, then a requisition is forwarded. That post has to be a sanctioned post. Without the same, your lordship, nobody can be taken appointment against a regular post.
Sanction post means sanction.
Sanction, lordship, I am aware. Sanction means
without sanction, no one can advertise for recruitment for a permanent post.
Lordship.
Number 1. If there is a sanction post, no permanent vacancy appointed, then contractual, they may engage for a particular period of time.
Grateful, my lord. For a particular period of time, there are rules also. I'll refer to the rules later on. But the rules also doesn't permit for an enormous contract.
Yes. If there is a permanent vacancy or permanent regular vacancy.
Lordship, there was. Lordship kindly grants me a moment time.
Because first question you have overcome that you
Lordship,
are
approximately
not
15 vacancies.
appointee.
Lordship.
You are appointed through advertisement.
Lordship.
Through written test or oral, whatever may be their procedure to be appointed, you have done from your side and they have selected.
Lordship.
Now here question is whether the post was approved or not.
Lordship, to that my answer would be the posts were all sanctioned posts. I have just ascertained there are 15 vacancies. 15 sanctioned posts. Even existing today. Even existing today.
Yes. Opposition has been filed in this case.
Lordship. And reply. Now, Lordship, thereafter, the contract were extended one after the other continuously without there being any gap even for one day.
There
The-
is no gap.
No, the only gap I've mentioned in my note, only gap was for a period of 1 day at the time of first contract. Thereafter, the same is continuous in nature. Now coming to the,
So every extension there was a 1 day break.
no, only first extension.
Only first extension.
Only 2012 extension. Only
Once.
1 day gap.
Once.
Once.
Okay.
Lordship, thereafter, page 62.
1 day break for all the petitioners.
All.
Thereafter, they are continuing.
They are all continuing. All till 31st March 2028.
Yes.
Now the most relevant document is at page 62.
62. Yes, 62. Yes.
Lordship, if at all my service is required, be on ad hoc, be on regular, whether a certificate is required to be issued in respect of me and the others who are regular. The answer is the similar certificate is issued even for the ad hoc dock pilots and even for the regular dock pilots. That is at page 62. It is issued none other than by the Kolkata Port Trust. This is to certify that Sri Somnath Giri, trainee dock pilot, has been duly examined by us and is hereby declared competent to pilot vessels inside the Holdia dock in the capacity of dock pilot. Lordship, similar such certificates are also issued in respect of the petitioner number 2 and 3, which is at page 65 and 69.
Yes.
So my second submission is that you have decided to extend the contract one after the other. Whether such nature of certificate, once I have obtained upon going through a training procedure, all the criteria with regard to a regular service was accomplished with. Whether every time the contract was extended, whether such certificate was issued every time, that is no.
Only once.
Only once.
After training, the certificate was issued by them.
Lordship.
And declared them you are a competent pilot.
Yes. You are certified. This is in the nature of a license. Like subject to correction, the authority which we have to practice before the honorable courts, we also have to obtain a license. We may have studied in different universities, but we have to obtain our license in the similar nature. Without this document, they cannot even enter the port.
So according to your submission, even if on contractual basis they have been appointed, they may be regularized.
They may be. Lordship, today, assuming a Lordship.
Because they have served the authority for a long period of time.
More than 10 years.
Without any break.
Lordship.
Without any adverse report.
Lordship.
So you are asking for regularization.
Regularization. Grateful, my lord. That is my first part of the case. Now to improve upon my case, I may also rely on page 100. What is the nature of duty today I am assigned?
Yes.
Lordship is at page 100 of the writ petition. As approved by the competent authority during any shortage and non-availability of assistant dockmaster permanent. In a particular watch, the 3 senior most berthing pilot on contract, that is Sri Somnath Giri, Shri Joydeep De and Shubhajit Mondal sequentially shall be performing the job as acting assistant dock master with immediate effect. So assistant dock master is a post higher. Where am I required? When there is an absence in the permanent post.
So this post is higher than the dock master, dock pilot.
Dock pilot, and subsequent that too is the dock master. So it's not only that I have been doing the duties of the dock pilots today,
as well
often
as you are acting as a assistant dock master.
Dock master, as and when required. We are rendering the service for more than 10 years now. Petitioner number 1 from 2012 and 2 and 3 from 2014 onwards. Lordship, thereafter, page 95. Lordship, thereafter, we had given applications, which is at page 92. I'll be referring to some of the applications.
For regularization.
Not for regularization. Lordship, in the nature, your Lordship, one is a pilot. He needs to use the stripes. So the stripes makes it easier for the persons present as to he is in what rank. Now, again, whether the differentiation between a ad hoc and a permanent. Assuming he is ad hoc, performing all similar nature of duties of the regular, and he is entitled to the stripes also. That is at page 19. May I place it? The petitioner number 1 has addressed to the Manager Marine Operation Division. This is to inform you that I have been working as a regular, regular dock pilot on contract. Presently, nomenclature changed to berthing pilot. I'll come to that, Your Lordship. With effect from 23/7/2013, my qualifying date. In case of permanent dock pilot, they're allowed to put 2.5 stripes on their epaulette after 10 years of completion of regular service. So this is also I was entitled to. Lordship, thereafter.
That was given to you? No.
No. Now coming to a most shocking notification which was brought upon, dehodes the existing rules. The rules does not speak of berthing pilot. Page 95.
Yes, 95.
Page 95 of my writ petition. Now this is another chapter of the story.
Yes.
What are the two chapters? I am on contract, number 1. There is a 15 years embargo, number 2. But the Marine Department could easily think
15-year embargo.
That is from their affidavit. That we are on a 15-year embargo only for dock pilots, not even for river pilots. Only for dock pilots, 15 years will keep you on contract, and suddenly one day we'll decide to issue fresh advertisement without even considering you. Today we have overaged. The qualification remains the same. 60% nautical science. We had some 69%, 67% in nautical science. Qualified, appropriate, proper channel of appointment, 15 years embargo remaining. Now there is another facet of the story, is the berthing pilot. What is that? Page 95, dated 14 January 2020. Redesignation of assistant manager berthing, dock pilot on contract under MO division. You may like to be informed that Deputy Chairman has approved redesignation of the contractual officers engaged in the berthing service of Haldia Dock Complex as berthing pilot. All other terms and conditions.
Pilot is a new
It's an ornamental name. Ornamental. All other terms and conditions of their contractual engagement shall remain unchanged. The following 9 incumbents engaged on contract as assistant manager berthing and dock pilot may thus be redesignated as berthing pilot. They please be informed and herein accordingly are acknowledged. So this includes the name of the petitioner number 1, 2, and 3, the first 3 of them. So more the merrier. We were working on contract. Now our designation are supposed to be changed so that we cannot figure out in any nomenclature henceforth. That's a very calculative attempt. In the year 2020. So thereafter, we have said that we are redesignated. Other criteria remains same.
What post they have advertisement?
Advertisement is apprentice dock pilot. No berthing.
No berth.
No berthing. I'll come to the advertisement, the first page.
Which was they have cancelled.
Which, Lordship, that I do not know, Your Lordship, whether it is cancelled or not.
Nobody found. That's why they have cancelled and new advertisement has been.
I am aware a new advertisement has come.
16th is the last date.
17 was the last.
17th, I'm sorry.
Tomorrow is the last date. Yes. Last occasion submitted from the side.
Lordship, 17. And the advertisement which I have assailed, 109. That is at page 109, Your Lordship.
That chapter is over now.
That chapter, Lordship, I'm only on the name. Direct recruitment for apprentice dock pilot under Marine Operation Division, Haldia Dock Complex. So a very calculative chance is taken so that the contractual persons, even those who are now redesignated as berthing pilots, whether at all the term berthing pilot figure out in the rules or not, we were made to do the similar duty redesignated as berthing pilot. Now, subject to correction, Your Lordship, once I'm redesignated, whether even at that point of time, I was required to have a fresh certificate of that of a berthing pilot. Since 2020, again, the answer would have been in negative. I continued to work with the certificate of dock pilot. And I was redesignated as berthing pilot.
The authority may redesignate any post. That is not the problem for you.
Lordship, I could not follow.
If the authority changes or redesignate the post,
Lordship,
that will hamper your post.
Lordship, the difficulty is that I am in their hands. Tomorrow, if they say I am putting you under this designation, I am putting you under that designation, whether I can voice.
But initially you were appointed as a dock pilot.
Yes.
As per the notification.
Lordship.
If the equivalent post they redesignated, where is the problem?
Lordship, the post, the redesignation, the concept does not exist.
You are saying that post is still not exist.
Does not exist. Wherefrom they have gathered 15 years embargo in their own affidavit. 15 years embargo not to appoint. 15 years embargo goes suddenly to redesignate the existing dock pilots. There has to be some semblance of thought. They are the authorities. They are the responsible authorities.
Okay. Next.
A ship entering the port and leaving the port. It's all maneuvered by the dock pilots. And if I am not wrong, berthing is only with regard to a ship entering. What about it leaving the port? Subject to correction. Right?
The duties are different.
Duty is only simple. The duty is very simple. Lordship, may I add on one statement? My husband is in the Merchant Navy, so I am aware of the terms. So I'm quite aware what is the duty of the pilots.
Duty of dock pilots and duty of berthing pilot is different.
No, absolutely not. Same work. A ship cannot enter the port or cannot leave the port without the signature of the pilot. It is that very important a post.
Okay.
And today, XYZ cannot do the same job. One needs to have a license. And that is what is issued by the Marine Division.
Yes.
Lordship. Now, Lordship, coming to the nature of duty. Lordship. Thereafter, coming to the scale of pay. Lordship, page 25, paragraph 41.
Yes, 25.
Page 25, paragraph 41. I'll also indicate the total number of vacancies. Para 41. The petitioner states that the vacancy arose since the year 2012-14 till 2024, but it was never felt necessary to offer the petitioner and others similarly circumstanced to participate against such existing vacancies. Vacancies are arising out of the sanction post. Once the list is produced before the Honorable Court, it shall be clear. The authorities have access to the same. Lordship, thereafter. Now, where are we deprived? Your Lordship, now coming to the principle of equal pay for equal work. Till now, I have pleaded on my submission was restricted that I am doing the regular duty of that of a regular dock pilot. Para 42. The petitioner states that respondents intended to take the service of dock pilot by paying much lesser. The petitioners were initially paid rupees 35,000 as consolidated pay, and they now receive rupees 83,100 as a consolidated amount, whereas the dock pilots are paid rupees 1,15,000 at the initial joining and are now paid rupees 2 lakhs. So this is the difference.
There are other pilots are there. Permanent pilots are there.
Permanent pilots are there.
But my learned field will consume rest of the day. So could I come back on some other day?
Let her complete.
Kindly fix another day for me to reply. If she
Today
finishes.
time is 15 minutes only there. Later,
Next week, my lord, if your lordship.
can you complete today?
Lordship, I'll be referring to two
Judgment,
judgments of very recent. Justice Vikramnath has delivered two judgments, which is overruling Uma Devi, Your Lordship. I'll be referring to judgment and naam duto dao.
Jago.
I'll be referring to Dharam Singh and thereafter Jago.
Jago.
I'll refer to that.
But that is applicable in this post.
Lordship.
That judgment is applicable in this post.
Lordship.
Those judgments are applicable in this post.
It is with regard to 10 years of continuous service. 10 or more.
Post is below, lower than the grade.
Lower than the grade, Lordship. Sir.
List this matter.
Lordship, because the only difficulty is that, Your Lordship, in the presence of the learned AG, Lordship, if I may say this, I tomorrow or day after tomorrow, Your Lordship, I can conclude the matter. My only prayer is that since the advertisement is in the process, if today the court decides in my favor.
No, you just you have said that 15 vacancies are there.
No, Lordship. I am with regard to the 3 vacancies. Why will I be placing for the 15 vacancies which I'm not aware of?
Please check how many vacancies were declared by the
Lordship. If tomorrow I succeed, Your Lordship, then in the other 3 posts someone is appointed, then I'll anyway be deprived.
It will take some time for appointment.
Yes, it takes a lot of.
Lordship, I am only
last date of submission.
Lordship,
No, my lord, whether at all if anybody has applied or not.
The last occasion you did not find any candidate.
No one applied. This time also I don't
Why
know.
you are not regularizing them? They have been appointed on the basis of notification. They have participated in written test. They also participated oral viva.
Yes.
They are continuing their experiences there. There's no
Let's see, my lord, whether they have any right or not. Because the triggering factor is my advertisement. Had my advertisement not been published, I'm sure the petitioners wouldn't have come to court.
They will apprehension. They have apprehension that any time they may be removed because now
their right to absorption is independent of my advertisement. Whether or not I publish any advertisement, if they have a right, they have a right. Otherwise, they don't have a right.
Yes.
But I'll address your Lordship on this.
I can dispose of immediately so that she can.
No, your Lordship considers the matter. Keep it sometimes next week after hearing my learned friend today.
Today you complete.
Lordship, I'll complete.
You complete your.
Right.
Your junior is there.
Yes.
You take note. Yes.
Lordship. I'm grateful, my lord. Lordship, thereafter, what is the deprivation? Now coming to the deprivation part, it is with those who would be regularly working today doing the similar nature
will come after you have been regularized. Otherwise,
Lordship,
you will not entitled for any.
I accepted that today I'm on contractual basis. In today's scenario, I have accepted.
Salary fixed by them.
Lordship.
Consolidated.
Lordship.
And you have accepted.
I have accepted.
So there is no question of any deprivation.
Lordship,
now
Lordship,
here question is whether you will be regularized or not.
As a matter of right.
Matter of right.
Right.
Only for the reason that you have appointed on the basis of notification, procedure has been maintained, vacancy is regular, and you are working since 2012 and 2014
Lordship.
Without any break. There is no any adverse report. So you should not be deprived
Lordship, grateful my
from the regularization.
Like,
This is your case.
This is my only case. My case is very simple.
Now you
And it has triggered from the advertisement. That also has been.
Question is whether a contractual employee can be regularized even in such situation when there is a vacant post. You have been appointed by following the procedure. You are not from back door. So Uma Devi will not apply here. Two other judgment which were subsequently passed by the Supreme Court is applicable in your case. You have to satisfy.
Lordship. Now again coming to the nature of work. Paragraph 20, page 26, paragraph 43.
44.
Page 26, paragraph 43.
Yes.
The petitioner states that, may I place it? States that their work is neither casual nor peripheral. Instead, it is the pivotal job of the Haldia dock complex, without which the entire business would collapse. The petitioner's duties are round the clock. When on an average 10 vessels are berthed and unberthed, I was trying to indicate this, within 24 hours, such berthing and departure recurs huge revenue to the Haldia dock complex, Kolkata Port Trust, and thus their service are not only crucial but unavoidable even for a day. Now, this is what is the factual background. Lordship, thereafter, coming to the advertisement I have pleaded, which is at page 40, para 47, page 27. The petitioner states that they have come across an advertisement dated 24 September 2025. Thereby, the port published an advertisement for direct recruitment for apprentice dock pilot under Marine Operation Division dock pilot. 3 vacancies were published. Paragraph 48. The petitioner states that the berthing section of the Marine Operation Division, Haldia Dock Complex, is responsible for all internal vessel movement within Haldia Dock Complex. The present manpower structure comprises of 1 deputy dock master, 4 assistant dock master, 2 regular dock pilots, and 9 contractual dock pilots. In bracket, I have stated berthing pilots. Lordship, this is the present scenario. I have already stated it. That the post of assistant dock master and deputy dock master are promotional positions for regular senior dock pilots who have acquired adequate experience and expertise in dock maneuvering operation. No external personnel can hold such post without undergoing the training, which the petitioners have undergone. The petitioners were engaged at the entry-level post of the cadre of dock pilots by the Haldia Dock Complex, keeping the requirements of a regular appointment of educational qualification, which includes marine certificates, age limits, and proper selection procedure. Since the petitioners qualified in all manner, dock pilot license were issued, which is identical to that of the regular dock pilots of Haldia Dock Complex. Thus, the petitioners were throughout serving the duties of dock pilots. When permanent vacancies arose due to promotion and retirement, but the Kolkata Port Trust authorities never felt the requirement to initiate recruitment process since 2012, 14 and 2017. Lordship, at that point of time, it had arisen, and thereby enjoyed the identical service of the petitioners of that of dock pilots. And at one point of time, it was suddenly proposed to re-designate the petitioners as berthing pilots when such contractual agreement was also not for such post of berthing pilots. That in service of dock pilots were received as recognized as a permanent post for the recruitment. Now, Lordship, coming to the relevant paragraphs I am stating. Para 51.
Yes.
The second sentence. Neither such appointments are backdoor appointments, nor illegal, nor irregular. The petitioner possesses the license of a regular dock pilot, thus confirming their service against the regular job of dock pilots. Now, Your Lordship, I'll be referring to the rules 2013. That is paragraph 52, page 31.
Yes.
The petitioner states that during their course of engagement, the essence of their employment was required to be considered in light of their contribution, which was unavoidable and continuous, and after more than 10 years of service. Your Lordship, this is what was the initial principle of Uma Devi. 10 years of service, a provision is made to recruit new apprentice dock pilot without absorbing or regularizing the petitioners against such arising vacancies. The Rule 2013 also provides that whenever any post is required to be filled by direct recruitment and the same is advertised, employees already in service may also apply provided they possess the prescribed qualification and experience. Age limit in such cases will not apply. Lordship, paragraph 55.
Yes.
Paragraph 55, again, the second statement. Furthermore, the contractual engagements were not discontinued, but with the arising demand, more such similar indicate engagements were made, but on contract basis. And at present, there are 9 dock pilots rendering similar nature of dock as that of the regular dock pilot. Presently, nine of them are working, where there are the 3 petitioners. Now, Lordship, coming to the rules. Page 36, ground 7.
36, yes.
Ground 7. May I? The Kolkata Port Trust employs recruitment, seniority, regulation and promotion 2013 further provide in Rule 9 that when the posts required to be fulfilled by direct recruitment are advertised. Lordship, I've just read it. Ground 8, ground 9. For that, the Kolkata Port Trust employs recruitment, seniority, promotion 2013 in Rule 14 provides for consideration of recommendation of service selection committee and ad hoc appointments. Rule 14 provides the power entrusted with the chairman in case of a purely temporary post where a leave vacancy or a vacancy earmarked for direct recruitment requiring immediate filling up. The chairman may appoint a person who is eligible to fill the vacant post for a period of 6 months at a time and not exceeding 1 year. Now, on ad hoc basis, subject to certain conditions. I have annexed the rules. Now, may I explain? So,
you have been appointed initially for 3 years.
Initially for 3 years.
It is not that yearly basis they have appointed.
Lordship, a requirement arises. Pursuant to the requirement, the chairman is given the authority that you take the initiative to overcome the immediate duress. It was overcome. It was of their benevolence that instead of 6 months, 3 years. But whether such benevolence at the behest of the chairman could have been more than 1 year. The definition of ad hoc is adequately explained in their own rules.
Yes, okay.
Ground 10. For that, their engagement, though on contract, was on an ad hoc basis. That is in terms of Rule 28 of the Kolkata Port Trust employees 2013, an ad hoc appointment is given in case of immediate necessity when a panel recommended by the Departmental Promotional Committee has been used up. The appointing authority may make a purely ad hoc appointment to a post by appointing the senior most eligible and suitable employee in the feeder grade or post up to a period of 6 months at a time not exceeding 1 year, or till a new panel is recommended by the departmental promotional committee, whichever is earlier. Again, their own rule speaks, dehodes their own action. Their action is not substantiated by their own rules. The ad hoc appointment, where unavoidable, should be made only strictly subject to fulfilling the qualification, comma, experience provided in the recruitment rules. May I pause here for a moment? So, the rules are making it clear that the qualifications are an integral part. So, the same persons coming with a qualification in 2012, 2014, that keen qualifications are also existing in 2025 and 2026. But I am deprived of my right. Now it is a question to decide whether I have a right to be absorbed, to be regularized, or whether the new incumbents tomorrow participating will replace me. And tomorrow I am jobless. Lashim, may I come back? I'll be relying on their affidavits, because their affidavits clearly speaks that on a 15 years embargo, they never felt the necessity.
Only on judgment of Jago and another judgment.
Lordship, I'll be relying on your Lordship. Dharam Singh and others versus State of UP and another. And আমি দিয়ে দেবো, আমি তোমায় দিয়ে দেবো। Yes.
They have made.
They have stated. They have stated.
What they have stated.
If I remember, your Lordship, the dog pilots previously named as birthing pilots.
Lordship, presently we have 3 vacancies which I'm aware of, which through the advertisement they're seeking to appoint.
Apart from their nine dog pilots.
Yes.
Apart from that, 3 more vacancies are there.
At the moment, the ministry has granted us the option to regularize or take on board 3 more appointments. So we have done that advertisement.
Okay. So there are other more posts are there, dog pilots.
So what is existing is existing. The ministry from time to time gives us that liberty to appoint and take on permanent basis. That is the advertisement which has now
They will not agree even if 3 persons were appointed as a dog pilot.
Their contract extends till 2028.
No, even if for regularization, if there is a post, regular post, sanctioned post, where is the problem to regularize them? Here is the question. When the appointment was after following the selection procedure or after notifications, they are working since 2012, more than 13 years has been passed.
Yes,
Still their service is till 2028.
Till 28.
So why their prayer cannot be allowed? That is the
question,
and you have to answer that.
Grateful, man.